That's great.
Thank you very much, my Lord. My Lords, I'm proposing to start this morning with an overview of our submissions on issue estoppel. In summary, what we say is this. Issue estoppel requires that the issue arising in subsequent proceedings is precisely the same issue as has already been decided in earlier proceedings between the same parties. And we say there are a number of reasons, or perhaps that should be there is a number of reasons, why that requirement is not satisfied in this case. First, the authorities on issue estoppel, to which I will take your lordships in a moment, make clear that the requirement that the issues be identical is an extremely strict one. The authorities also make it clear that this exercise is approached in a technical way. It is not at all the same thing as deciding how the reasoning in a previous case would apply to a new set of facts that are now before the court. So it is not like seeking to apply an authority or to say an authority is not applicable. Issue estoppel does not arise on this case for a number of reasons. First, there are substantial differences between the factual allegations underlying the earlier claim and the factual allegations underlying the new claim. And the fraud allegation is not the only difference, as I will show your lordships in due course. Second, it is necessary to focus on the issue that Mr. Justice Andrew Baker decided as between SKAT and ED&FM, as between SKAT and ED&F man. And that needs to be looked at in isolation. One should not be looking at any issue that he may have decided as between SKAT and the alleged fraud defendants. Again, I will show my lords why the wording of the issue requires this. 4. The issue that Mr. Justice Andrew Baker decided as between SKAT and ED&F man is not affected by the fact that there may have been other issues that he decided as between SKAT and the other defendants.
You said 4. Mr. Graham.
Sorry, I said 4. That's because I had a little Roman 4 written by the side of my paragraph. It was, in fact, the conclusion of my second point.
Right.
So I'm very sorry about that.
That's not 4.
So it's not 4 at all. It's the end of 2.
Thank you.
And that is very helpful that your lordship interrupted me that way, because my next paragraph begins third.
Yes.
Third, in order for issue estoppel to arise in relation to any point, that point must have been decided by Mr. Justice Andrew Baker, and it must have been necessary for him to decide it in order to answer the preliminary issue as between SKAT and ED&F man. It follows from the points I have been making so far that it cannot be right that issue estoppel arises in relation to a point that did not arise on the then pleadings between SKAT and ED&F man. My lords, I propose to develop each of those submissions, but I'm going to say something about the legal principles first. The legal principles that govern issue estoppel were common ground before the judge, and he recorded that at paragraph 33 of the judgment. From my lord's notes, unless you want me to, I'm not going to take you to it. That's Core Bundle, tab 6, page 76. And the judge then articulated those principles in paragraphs 34 to 42, that is behind tab 6, pages 76 to 78. And my learned friends do not identify any inaccuracy in the judge's formulation of those principles. But if I may, my lords, I propose now to show you one or two of the authorities that Mr. Justice Bright relied upon. And the first authority I propose to take up is the decision of the Appellate Committee of the House of Lords in the New Brunswick case. And your lordships will find that in volume 1 of the authorities bundle at tab 3. The facts are set out in the headnote, but to summarise them very briefly, the Appellant Railway Company had issued a series of 6,000 bonds, all in the same form, amount and date. And the respondent was a holder of a large number of these bonds, 992 of them, in fact. The respondent had previously obtained default judgment in respect of one of the bonds, bond number 3,300 as it happens. and the question was whether that judgment created an issue estoppel as to the construction of other bonds in the same series. To see their lordships' articulation of the principles that govern that question, might I invite my lords please to turn to page 19 of the report, which is at page 46 of the bundle. And here, as you can see, we are in the speech of Lord Maugham, the Lord Chancellor, and I'm going to start, if I may, with the very last sentence, which you'll see at the bottom of that page. Do my lords see the words, "The doctrine of estoppel is one founded on considerations of justice," if one goes over the page, good sense. If an issue has been distinctly raised and decided in an action in which both parties are represented, it is unjust and unreasonable to permit the same issue to be litigated afresh between the same parties or persons claiming under them. But in my view, the doctrine cannot be made to extend to presumptions or probabilities as to issues in a second action, which may be, and yet cannot be asserted beyond all possible doubt to be, identical with those raised in the previous action. So, my lords, just pausing there, in this passage, Lord Maugham emphasised the very high standard that a party who invokes issue estoppel has to satisfy. As he put it, that party must show, beyond all possible doubt, that the issues are identical. And at the top of page 20 of the report, you lords will have noticed Lord Maugham referring to the issue needing to be distinctly raised and decided in an action in which both parties are represented. So although in the New Brunswick case, the issue estoppel was said to have arisen from a default judgment, Lord Maugham contemplated that the same principle would apply to judgments given in proceedings where both parties were represented. Picking it up from where I broke off, Lord Maugham continued, in the earlier action here, the only relevant issue was as to the true construction of the only bond then sued upon, and an allegation that other bonds of the same issue were in precisely the same form would have been irrelevant and improper. In fact, however, the statement of claim contained no such allegation. Nor is it true to assert that all of the bonds of such an issue are necessarily in the same terms. The issue of construction in the second action could indeed be proved in the second action to be similar to that decided in the first, but it related to a different cause of action based on other bonds and could not be asserted to be the same issue. Moreover, it is a matter of common knowledge that such bonds are often issued at different dates and in different countries, matters which might well have a possible bearing on their construction. The defendants in the first action, in special circumstances, might themselves have been estopped from contending as against the plaintiffs for the more limited construction of bond 3,300 there sued upon, whilst there might have been no such estoppel as regards the 992 bonds. Just pausing there, my lords, this is the reason I hesitated to give a definitive answer to my Lord Justice Popplewell's cargo hold example yesterday. For example, if what is being carried in hold number 3 is oranges, while in hold number 4 the cargo was machine guns, the nature of that cargo could conceivably make a difference to the application of the sovereign immunity rule. So there would be, we say, no issue estoppel unless and until it was shown, beyond all possible doubt, that the issue arising in relation to sovereign immunity, in relation to the state's claim in respect of hold 3, was precisely identical to an issue arising in the subsequent action in relation to the cargo in hold 4. Now, it may be that it could be shown beyond all possible doubt that the facts were identical. There was sufficient identity that it was no doubt at all that the issue had been decided as between these two parties. But that is what's required. Going back to New Brunswick, if I may I now show my lords Lord Romer's speech in the same case. And for that
Do we need to read any more? I mean, I see there are more marked passages in Lord Maugham.
Yes.
Are they helpful or not helpful?
What they deal with, my lord, is the impact of default judgment on this. Your lordships will have noted that I read you the passage at the top of page 20, which makes clear that Lord Morn is dealing with a situation which both parties are represented. A further reason he gave as to why in this case it would be there was no issue of estoppel. It was in relation to the fact that it was a default judgment and it wasn't open to the appellant defendant to raise any points in relation to any other bonds on that occasion. But that's why those areas are sidelined, I think.
So I'm just looking on in 21.
Yes.
He says he doesn't think it necessary to express an opinion as to whether the estoppel would have succeeded if the appellants had appeared in and contested the first action.
Yes. So he's saying, I think it is helpful for me to mention at the bottom of page 21, the sideline passage. In my opinion, we are at least justified in holding that an estoppel based on a default judgment must be very carefully limited. The true principle in such a case would seem to be that the defendant is stopped from setting up in a subsequent action a defence which was necessarily and complete with precision decided by the previous judgment. In other words, by the res judicata in the accurate sense. But I think I think he's making the point that on top of his statement of principle, which I took you to in pages 19 to 20, there is an additional point here in relation to default judgment.
Is that interpretation consistent with the passage at the top of 21 where he says he doesn't think it necessary to express an opinion as to what the position would have been if the previous claim had been fought out? I mean, that suggests that he's limiting the scope of what he's saying.
Well, what he's doing is he's saying, so far as the facts of this case are concerned, he doesn't need to he doesn't need to express an opinion if the appellant had appeared and contested the first action. But what I'm relying on the judgment for is the statement of principle, which your lordships will see on page 20, which is expressed in wider terms than that which merely applies to a default judgment.
Yes,
because Lord Morton goes out of his way to say if an issue has been distinctly raised and decided in an action in which both parties are represented. So he's stating a principle there wider, perhaps, then he goes on to decide to say he needs, but that principle is the principle for which, in our respectful submission, the case is cited and has been cited recently.
Yes, yes.
Can I go forward then to page 43 of the report, which is on page 70 of the bundle, starting, if I may, at the top of page 43. Lord Roma said this: "It is no doubt true to say that whenever a question has in substance been decided, or has in substance formed the ratio of, or been fundamental to, the decision in an earlier action between the same parties, each party is stopped from litigating the same question thereafter. But this is very different from saying that he may not thereafter litigate not the same question, but a question that is merely substantially similar to the one that has already been decided. If in an action the question of the construction of a particular document has been in substance decided, each party to the action is stopped from subsequently litigating the same question of construction of that particular document. But he is not stopped from subsequently litigating the question of construction of another document, even though the second one be in substantially identical words. For the documents are two distinct documents, and the question of their construction are two distinct questions." Now, my lords, we would say in this passage, Lord Roma highlighted the exacting standard that needs to be met before the court will find that issues are identical. As he put it, it is not sufficient that the issues are substantially similar, they must be the same. And the example Lord Roma gave of the application of that principle is, with respect, highly instructive. He referred to two documents with substantially identical words, and he held that a judgment regarding the construction of one of those documents does not create issue estoppel as to the construction of the other. That is because, as he explained at the end of the passage I just showed your lordship, the documents are two distinct documents and the questions of their construction are two distinct questions. So I pause to observe in parenthesis, as it were, that there is no suggestion anywhere in this passage of Lord Romer's that the application of the principle stated here is confined to issue estoppel arising out of default judgments.
If I just looking back at 41
Yes.
or 68, I think he's saying that.
He is. I was about to take my
Yes,
notes
I see.
to that.
Yes.
I was going to say, to put that beyond doubt, could I show my lords a passage from Lord Romer's speech which appears at page 41, at page 68 of the bundle, but if your lords already have that point, I perhaps don't need to take you through it. But what he's saying is, whether let me just read it quickly. Whether a judgment by default can ever be relied on as res judicata, and if it can, whether the judgment alone is to be regarded, or whether the whole of the proceedings may be looked at, are questions upon which I do not find it necessary to express any opinion. For assuming both those questions to be answered in favour of the respondents to this appeal, and the respondents were the claimants trying to sue on the 992 bonds, I am unable to discover anything in the judgment or in the record of the proceedings in the former action that can stop the appellants from now litigating the question of whether the amount of interest payable under the 992 bonds sued upon in the present action. And so Lord Romer was not drawing any distinction between the application of issue estoppel to default judgments and judgments given in contested proceedings. Rather, he was proceeding on the assumption that the doctrine of issue estoppel would apply even if the previous judgment was given in default of appearance of one of the parties. And my lord, the case of New Brunswick has recently been relied on by Mrs. Justice Cockrell.
Just before you go there,
Yes.
I mean, if we get potentially two different views expressed by Lord Morm and Lord Romer, where do the other members of the court come down?
Lord Russell, I think, decides it just on the default judgment point at page 28. We get my lord's numerous authorities cited. None would justify us in adopting the view, much less compel us to do so if the doctrine applies so as to stop a defendant against whom a default judgment has been obtained from raising as a defence. Then we get the citation from Hoisted, and then about 2/3 down. These, no doubt, are wide words, but they relate to a case of estoppel by a judgment in contested proceedings, and I'm not prepared to extend them to the case of a default judgment on a claim under Contract A, followed by an action under a similarly worded Contract B.
Yes, he goes on to say, I would only add he agrees with what the Lord Chancellor has said about the undesirability of making declarations on the construction of documents, except after arguments on behalf of all persons.
That's a slight, they rather, Lord Justice, Lord Morm was rather dismissive of the idea there should ever have been a declaratory judgment in the first default judgment at all. But that's a slightly different point.
But that's a different point. We would say, both by looking at the Lord Morm's statement of principle, he is specifically saying that this applies whether it's a default judgment or not. In fact, he specifically says it applies where both parties are represented. That and Lord Romer's view of the matter make clear that what their lordships were intending to do was, yes, to decide a case that related to where the earlier decision had been a default judgment, but also to state a principle that was of general application.
Yes, I just sort of follow through my Lord's point as to what everybody else said. I think then Lord Wright majors on the no default judgment point, but might be said to be going, which he does over several pages from 37 onwards, following the paragraph, no authority has been produced in which a party has been held to be stopped from raising in litigation an issue which he might have raised in this litigation, in which he allowed judgment to go by default and omitted to raise the issue, and that's rather developed. But it's fair to say that you can point just above that to some more general words he uses.
And again at 38, there's an even stronger reason against admitting the estoppel. And he says there wasn't any issue before the court as to the 992 bonds.
Yeah.
It wasn't a traversable issue.
And just above at 37. It's enough to say they don't refer to default judgments, but then he goes on to say, or to cases arising in respect of different bonds or instruments, or to different states of fact, even if they appear to be identical. And then I think if I've got it right, Lord Thankerton says he agrees with everybody on that.
Well, he says, I think he says he agrees with Lord Morn.
No, he says recent stated by my noble and learned friends.
Friend.
So he agrees, with
26.
agrees with everybody in the result.
Yes. Yes. But my lords, we say, even though that was a case where the first action was decided on the basis of a default judgment, what the House of Lords had to say, what their lordships had to say, was expressly framed in words that would apply generally, and specifically they addressed the situation where both parties are represented, and the words I referred to about the need for the issues being shown to be the same beyond all possible doubt is specifically in relation to such an example. My lords, I was going to say that decision in New Brunswick has recently been relied on by Mrs. Justice Cockrell in the SAS Institute case. That is at the authorities bundle tab 3. First case behind that is tab 21. And if within that, my lords could go to page 756. Page 681 of the judgment. And you'll see in paragraph 41, Mrs. Justice Cockrell refers to Arnold and National Westminster Bank, and the quote there, which you see sidelined. Then there's a reference to Virgin Atlantic and Lord Sumption's explanation that Arnold is the authority for those three propositions. And then she says 43 other formulations are, and then issue estoppel only applies if an issue in the second proceedings is the same as the one decided in or covered by the first. Reference there to Spencer Bauer. The decision was a decision on the very point of issue, a case called Vervaeke against Smith. And then 3, it must be possible to say beyond all possible doubt that the issues are the same. And it is insufficient for that purpose if they are merely similar, even substantially similar. And there's a reference to the principle on page 20. So in our respectful submission, New Brunswick has been referred to relatively recently, and of course I'm being reminded that SAS, the Institute case, was not a default judgment case. At paragraph 37 of Mr. Justice Bright's judgment below, that's on page 77 behind tab 6, the judge referred to the speeches of Lord Morn and Lord Romer in the New Brunswick case as supporting the proposition that the test of identity of issues is applied, quotes, very strictly. We don't need to turn that up unless you, my lords, would like me to, but we do say that the judge was plainly right to say what he said there. My lords, the next authority I propose to go to is a decision of this court in Todde and Todde. I hope that's the right way of pronouncing it. I apologise to their descendants if it's not. You will find that in Authorities Bundle, Volume 1, Tab 5. Mind you, on the facts of the case, it may be they didn't have any descendants, I don't know. But the passage that the judge cited from this case is that cited by, it's the definition of issue estoppel by Lord Justice Dipplot. And we can pick that up at page 198 of the report, which is at bundle A171. And picking it up just after just at the sidelining there, he refers first to, at the top of the page, he's referring to, I think, cause of action estoppel, estoppel per rem judicatem. And then the second species, which I will call issue estoppel, is an extension of the same rule of public policy. There are many causes of action which can only be established by proving two or more different conditions are fulfilled. Such causes of action involve as many separate issues between the parties as there are conditions to be fulfilled by the plaintiff in order to establish his cause of action. And there may be cases where the fulfilment of an identical condition is a requirement common to two or more different causes of action. If litigation upon one such cause of action, any of such separate issues as to whether a particular condition has been fulfilled is determined by a court of competent jurisdiction, either upon evidence or upon admission by a party to the litigation, neither party can, in subsequent litigation between one another upon any cause of action which depends upon the fulfilment of the identical condition, assert that the condition was fulfilled if it has, in the first litigation, determined that it was not, or deny that it was fulfilled if, in the court of the first instance litigation, if a court in the first litigation determined that it was. But the passage I would propose to take you to next and ask you to focus on as well is in Lord Justice Wilmer's judgment at page 191. My Lord see the first paragraph to start on that page begins with the word fourthly. I'm sure there's not an error. Lord Wilmer says here, fourthly, however, apart from cases in which the same cause of action or the same plea and defence is raised, there may be cases upon which a party is held to be stopped from raising particular issues, if those issues are precisely the same as issues which have previously raised, and have been the subject of adjudication. But in formulating that proposition, I would go on to say that it is very necessary to look at the particular circumstances of the individual case. The reason for saying that is that the adjudication in the previous suit may have been arrived at for a number of different reasons. If it is not clear from the judgment in the previous suit that the particular issue has in fact been specifically dealt with, a party will not be held to be stopped from raising that issue again in a subsequent suit. Now, Lord Justice Wilmer, in our respectful submission, is making 2 points here. He says, firstly, that in order for issue estoppel to apply, the issues must be precisely the same. That is the test that the judge applied in this case. And for my Lord's note, that is reflected in the judge's words precisely identical in paragraph 43 of his judgment, the judgment below. That's at C tab 6, page 78. The second point Lord Justice Wilmer makes is this. The court must consider the particular circumstances of the individual case. And upon considering those circumstances, if it is not clear from the judgment whether the particular issue has in fact been specifically dealt with, the court must find that issue estoppel does not apply. So, my Lords, we would say both New Brunswick and Todde and Todde are authorities that emphasise the very strict standard by reference to which the court will test whether issues are indeed identical for the purposes of giving rise to an issue estoppel.
I mean, the funny thing here is it's perfectly clear what Mr. Justice Andrew Baker decided and on what basis. He was deciding as an issue, potentially, whether where SCAT seeks to recover sums that it has mistakenly paid out, that's barred by the revenue rule. So we know that that was the basis on which it was decided. The question then is whether that is an issue that is capable of creating an issue estoppel and is common to the two sets of proceedings, which on the face of it is.
Well, my Lord, I would respectfully suggest that that is not the issue. The issue depends on the facts. And the facts in this case are the facts as between SCAT and ED&F man. It is the pleaded case against ED&F man, which, as I will show your Lordships in a moment, was the basis of the factual basis for the decisions which Mr. Justice Andrew Baker made as regards the case against ED&F man. So we say, when you look at the actual issue that was decided with this strict technical set of specs on, as to what you need to be doing here in our respectful submission. You say he starts with a pleaded case against ED&F. And that was, because it was being tried as if it was a strikeout, the facts pleaded were assumed to be true. And he then goes from that factual basis towards looking at whether that factual basis gives rise to a problem with Dicey Rule 3. To the extent that he pronounces a proposition of law that goes wider than he needs to go for that case pleaded against ED&F, that is all very interesting, and no doubt has got a lot to do with the fact that he was not just dealing with the case against ED&F man. But if you go back to what I submitted to your lordships as a preliminary point, if you concentrate, as in our respectful submission you should concentrate, just on the lists as between SCAT and ED&F, what you will, in our respectful submission, inevitably conclude is that the factual foundation for Mr. Justice Andrew Baker's decision on the ED&F man claim was that, given those facts meant that what SCAT was seeking to do as against ED&F was what it was seeking to do against a lot of other people. But that doesn't matter. For our purposes, all that matters is that he concluded that if he assumed as true the facts which SCAT pleaded against ED&F, that set of claims was barred by the revenue rule. Okay. And if he expressed himself as a wide proposition that any claim for compensation in respect seeking to get refunds back, that is not necessary for his decision on the claim as against ED&F. And as we know, it is only matters which are necessary, essential and fundamental to the decision taken in the courts below that are caught by the rule.
So, sorry to interrupt you.
No, please, my lord.
The claims as pleaded involved a specific sum of money, or the total of all those particular vouchers.
The particular ED&F vouchers?
Yes.
Yes.
So was that a fact that was critical to the outcome?
Well, there was a series of facts which we say were critical.
Yeah, you say all the pleaded facts.
All the pleaded facts.
You don't actually discriminate amongst any of them.
No, because I don't need to, because the facts that are pleaded in the current claim are so obviously different.
Well, never mind that. Let's focus on the principle.
Yes.
I think your submission is you've got to look at all the pleaded facts, not a smaller subset of them, which are those facts that are material to the issue which is being addressed. And it's that on which I'd like a little help, because if that's right, then if they'd happened to have said, and what's more, the vouchers were on blue paper, that would be a pleaded fact. But surely,
no.
surely it can't be critical. It can't affect whether the issue is the same.
That is undoubtedly a num question.
Yes. Luckily, in this court, I don't mind a bit of Latin, but I'm like the master of the rolls. But what I'm just trying to explore with you is, if you only take some of the pleaded facts as having to be identical, how do you identify those that do have to be identical and those that don't?
Well, you look at whether the fact in question could conceivably be relevant to the decision that was made. So if you take a view that the fact that the tax vouchers were on blue paper could not conceivably be relevant to the decision that Mr. Justice Andrew Baker reached as against ED&F man, then you can ignore that fact. But if there is a fact which could conceivably be relevant, which you cannot say beyond all possible doubt that it couldn't have affected the issue so far as the claims against ED&F were concerned, then that is a fact you would take into account.
Can I just relate this back a moment to Lord Justice Diplock? back at 198.
Yes.
He says cause of action involves as many separate issues between the parties as there are conditions to be fulfilled by the plaintiff in order to establish the cause of action. Now, what you're suggesting at the moment might be thought to be inconsistent with that, because you say, well, you have to put all the facts in, whereas Lord Justice Diplock seems to be contemplating that there might be individual issues which don't depend on all the facts. So might it be said in this case that one of the conditions that you had to fulfill to succeed was satisfying Mr. Justice Andrew Baker that a claim by SCAT to recover money that it had mistakenly paid out was not barred by the revenue rule? If so, then that's an issue on which he arrived at a decision which was necessary to be, which reflected a condition that you had to fulfill as the claim was then pleaded, and is also a condition that you have to fulfill as the claim is now pleaded.
But I had to fulfill it in the first action only insofar as it related to the facts of that case. And it does not matter in our respectful submission if the way Mr. Justice Andrew Baker expressed himself was in making an extremely wide proposition of law. That was not necessary for his decision as between SCAT and ED&FM. As between SCAT and ED&FM, you need to look at all the facts that were pleaded. You can discard those which could not make any difference at all. And you might, no doubt, as Lord Diplock would encourage us, concentrate in particular on the particular staging posts to a successful claim in negligent misrepresentation. If your case in negligent misrepresentation involves the possibility that the pension plan clients, the PP clients, the US pension plan clients, actually were the holders of shares, did actually receive dividends, but held them as nominee for ED&F man themselves, well, one can see that there is an important factual allegation which might well have a difference to the outcome of this decision, because it might be said that it was conceivably relevant to the question of whether there was a tax authority relationship.
But no one suggested at any stage, as I understand it, that the question of whether it was negligence or fraud could have any bearing on the application of the revenue rule. It was an irrelevant fact for not just the judge's purposes, but for the purposes of all counsel, as I understand it.
Well, I'm not sure that that actually is correct. We put in submissions in relation to ED&F man earlier on, but my point is not so much, and I'm going to come on to the question that the pleading of fraud or not pleading of fraud makes, and what one needs to look at for the purpose of deciding whether fraud makes a difference. And of course, when we come to look at that, whether fraud makes a difference, we're looking at it through our perspective from where we are today, and we're looking at it from, is it right that as the law stands in 2024, brackets end of, that the fraud makes no difference to the revenue rule? Well, we need to look, and we'll need to look and see what the law says about that now. But my point in trying to concentrate on the facts is partly because of a very important part of the judgment of Mr. Justice Andrew Baker, I'm going to come to, I promise, but it's also because you can see on the facts of the claim that's pleaded against ED&F, where there is the possibility that ED&F man was the beneficial owner of the shares or the dividend, meaning that the pension plan clients were actually the parties who received the dividend, who actually did receive a dividend, a case that reaches the view that if it is argued that such a claim falls foul of the revenue rule, you can see if you change the facts so that the pleaded case is that these pension plan clients never owned any shares, never received any dividends, never suffered a withholding, a deduction of withholding tax, that is going to be a different case. And we are, as it were, a million miles away from the putative possible differences between two bonds in very similar form that might have been issued and that were the subject of the consideration in New Brunswick. We are here looking at a pleaded set of facts, the important points of which are, these were the representations that were made, they were false in this way, and the way we said in the first claim that those representations were false was materially different to the way we are proposing to say that the certain similar representations were false in this current claim. There are also representations...
You say it doesn't make any difference that we know that for Mr. Justice Andrew Baker, by whose judgment you are bound, thought it made no difference whether it was a fraud claim or a negligence claim or what the representations were. The ground of his decision was, if a taxing authority pays a refund of tax and later decides that it shouldn't have done and was misled into doing so, it's filling a hole in the tax take, and that's the exercise of, that's a revenue claim. And on that formulation, it makes no difference what the representation is, whether it's made innocently, negligently, or deceitfully, or whether you're suing the recipient, or you're suing a conspirator, or someone else who's responsible for misleading the revenue. And so your identification of factual differences between the claim you now want to plead and the claim you previously pleaded wouldn't have made any difference to his decision at all. We know that, not because he decided other cases, but because of the way he decided your case against Mann.
But he didn't need to decide anything in respect of my previous case other than the fact that the case as pleaded against Mann fell foul of the rule.
Well, can I ask you this then? Suppose we know there are 5 new cases.
Yes.
Could you now bring claims in relation to those 5 new cases alleging exactly the same type of negligence as you alleged in the previous claim, or would you be stopped from doing that?
That would depend on whether there was any conceivable basis of difference between those 5 and the other 281. I would say this would be quite close to the New Brunswick situation. I say I'm a million miles away from that. But if you could show that there was no difference at all,
well, the facts are different because they're different they're different vouchers. I mean, but the representations might be identical.
Yes, but I think my main response to my Lord's question is saying it is obvious how Mr. Justice Andrew Baker would have decided anything that was not before him
is irrelevant.
That is not the test in our respectful submission that your Lordship should be applying. The question is not how Mr. Justice Andrew Baker would have decided our case. The question is, what was it necessary and essential and fundamental for him to decide in order to reach the view that the claims pleaded against ED&F Mann fell foul of the rule? And to the extent that he expressed himself in terms that went beyond that factual platform, it doesn't matter. All you're doing then, in our respectful submission, is saying, I am going to apply Mr. Justice Andrew Baker's judgment as an authority. That's not the test. The test is this precisely the same issue? And there has got to be in our respectful submission, a key matter of applying the relevant principles of law to the facts. And the facts in this case were the facts pleaded against ED&F Mann.
But can I just come back to my Lord's question about the 5 extra tax vouchers?
Yes.
I think initially you said it depends upon whether there's any conceivable difference about them that could make a difference.
Yes.
Assume not that the new claim is only in relation to these 5 new tax vouchers and the pleading is identical in every respect other than it applies to these 5 tax vouchers. Would an issue estoppel arise in those circumstances?
Well, I'm not sure it would actually, because I think it would be. I don't think any part of what had been decided in relation to the earlier claims would be relevant. Would be a necessary step so far as these claims were concerned.
And that's because, is it, the particular tax vouchers that were being sued on in the first proceedings are themselves facts which might conceivably make a difference.
Make a difference. So that, for example, if a particular voucher had a particular statement about, I don't know, tax withheld, and used the phrase tax withheld rather than simply the word tax, that could conceivably make a difference.
Even though one is in a position to identify that, on the hypothesis we're looking at, there is nothing which could conceivably make a difference to the issue as formulated.
Well, that certainly seemed to, yes, my lord, because that seemed to be the approach taken by the House of Lords in New Brunswick.
Yes, and I think that is the logic of your
I think
of
that
your
is
argument.
the logic of my position. The point is, we're not in a situation where someone has come along and said, you can see this is absolutely identical. There is no difference here at all. This is a cargo in hold 3 full of oranges and a cargo in hold 4 full of oranges. You don't know. We don't know. It hasn't been, no one's established, no one's proved that there is this precisely the same issue involved.
But I think it also follows from your submission that in my example of the cargoes, assume complete identity of factors that are relevant to state immunity. It's the same contract, the same ship, the same voyage, same parties. And even if there are oranges in both holds, if you sue first because you found some damage in hold 3, and that's resolved, and then you sue for damage because you've subsequently discovered it to the oranges in hold 4, I think the logic of your argument is that issue estoppel doesn't apply there either.
Well, it depends. What is the level of your knowledge? What is the level of information about the case on hold 4? If the level of information you already have about hold 4 is such as to show you that there is no conceivable difference, there's no possible doubt that the hold 4 claim has been decided.
So when you say level of knowledge, do you mean the court's knowledge
Yes.
or the party's knowledge?
The court's knowledge. The court's knowledge. So the reason why in the House of Lords case in New Brunswick, the House of Lords was not prepared to say this bond, the decision on the meaning of bond 3,300 affects all these other 992 bonds, was because they weren't prepared to say without knowing
So
whether
they're all in the same terms.
they're all exactly
all governed by the same law.
exactly.
Yep. But if the court is in a position to say that couldn't conceivably make a difference
Then
to the issue, the issue estoppel does arise, you say, notwithstanding the fact that actually these are new oranges,
yes.
as would be 5 new tax vouchers. Why is the position different between the two cases?
Well, it's not. The point I was trying to make to my lords was where you don't know exactly what the position is in relation to the 5 vouchers, you cannot say that they would be estopped if the claim pleaded in respect of them was the same claim. You would need to be sure that the factual elements of those 5 tax vouchers were so precisely identical that no conceivable difference could arise.
Thank you.
Where do you get the phraseology "no conceivable difference"? I think it was something that Lord Morm said, was it?
I think I was paraphrasing Lord Morm saying "beyond all possible doubt," and I'm told he did say those words as well.
I think you read them to us, but I can't now find it.
Let me find them.
Beyond all possible doubt, is it on page 20?
Yes,
6
it is.
lines down.
It is, absolutely. And then but I can't remember where the bit about it. Maybe it's in the speech of Lord Roma.
No, I think my Lord's right. It's on page 20.
Page 20.
About 7 lines down.
An area beyond all possible doubt. Like
Yeah,
thought to mean essentially the same as no conceivable difference.
Yeah, that's what I would say. But I'm being reminded that the language of no conceivable difference does appear. I just am not able to lay my hands on it at the moment. So, my Lord.
So can I?
Yes.
Can I be clear about this? The point is not that you're suing on a separate bond or you're suing on a separate tax voucher. The point is whether suing on a separate bond or a separate tax voucher conceivably might raise a different issue. Is that right?
Yes.
Even though we know, given what Mr. Justice Andrew Baker decided in your case against Mann, that whether it was fraudulent or negligent or what the precise representations were, would not have made any difference to him.
That's right, because insofar as he went wider than deciding the matter on the precise factual allegations which he assumed to be correct for the purposes of the exercise on which he was engaged, he was not. So if he went wider than was necessary for that purpose, he was not deciding something which was necessary, essential, and fundamental to the thing he had to decide, which is whether, on the claims currently pleaded, those claims fell foul of the rule.
Well, but how does that get you around the blue tax voucher problem? If the claims are pleaded as being by reference to vouchers that were on blue paper, all that needed to have been decided was whether all the facts, including the fact that they were on blue paper, gave rise to the application of the revenue rule. But I think we're agreed that's not. You've got to select some of the facts.
Well, I think what you do is you select the facts which are important. They're the facts on the staging post to establishing a claim in negligent misrepresentation.
They're the ingredients of a cause of action, is it?
Yes. So when you look at what Lord...
Duty, breach, damage.
Yes, but you also need to keep an eye on the facts, because the facts may mean that there is some relevant difference.
But it can't be just by reference to causes of action, can it? If we go back to our oranges example, suppose that it's the same cargo we're talking about, and the first claim is brought in contract, and the second claim is brought in bailment.
The question would be...
No issue of estoppel, even though that's entirely irrelevant to issues of state immunity.
If it's shown that the decision on state immunity is precisely the same in the sense I've tried to explain, then there's an issue of estoppel.
So it can't be that the way you choose which facts are relevant or not is constrained to causes of action. We must be making a selection of relevant facts by reference to some other criterion, to which I come back to what seems to be the obvious answer, which is what are the facts which are relevant to the issue as decided?
Yeah, can any of these facts conceivably be relevant to the issue that's been decided?
Well, the conceivably be relevant, or possibly make a difference, or whatever it may be, is looking to a point of time in New Brunswick at which it's not yet known what the issues in the second set of proceedings are concerned. But if the court has the knowledge, both how the issue was decided in the first set of proceedings and what the issue is, or how the claims are framed in the second set of proceedings in order to determine whether the issue is precisely the same, why are we concerned with facts that might conceivably make a difference when we know they didn't make a difference? Because I'm just reformulating my Lord Justice Nugee's point.
My Lord, I see the point. I think my answer comes back to the fact that what is the issue below was a question of were these claims barred by Dicey Rule 3, and what can be the subject of an issue of estoppel in that connection is only what is necessary, essential, and fundamental to reach that decision. So if there is a wide proposition of law promulgated by Mr. Justice Andrew Baker that such and such is the case across the world, across any set of claims that might be brought, that is not relevant because it is not necessary and essential and fundamental to the decision he had to reach as between SKAT and ED&F.
I rather suspect that the implication of your arguments is that no estoppel arose from Mr. Justice Andrew Baker's decision except as to his ruling on the particular revenue rule issue which he had been asked to decide. So no issue estoppel other than in respect of the issue that he was specifically deciding. Do you think that would be right?
When you say the issue he was deciding, my Lord?
Well, I forget how it was framed. He had been asked to decide as a preliminary issue the revenue rule point, and he arrived at a conclusion on it. I suspect your submissions carry the implication that no other issue estoppel could arise at all.
My Lord is largely right. My submission is that what he was deciding on the preliminary issue trial was exactly the issue which he posed to himself. Are SKAT's claims, as alleged, inadmissible by the application of Dicey?
It means those claims, the 420,
those claims.
the 420 negligence claims.
Yes.
Not other claims.
Exactly.
And there is, I mean, you don't look beyond that issue to individual issues that he might have been thinking about behind arriving at his overall conclusion. There is simply no issue estoppel other than on the broad issue.
That is right, unless you could show, as I said,
But there's no conceivable difference.
Well, unless you could show there was a sub-issue which was necessary and essential to his decision on those claims.
But he thought there was. He thought there was a sub-issue, which was it possible for SKAT to bring a claim to recover sums it had mistakenly paid out compatibly with the revenue rule? And he said no. But that, you say, is not a sub-issue. All that bites is the overall determination.
Exactly. I mean, you can look at individual issues, but those individual issues, in our respectful submission, cannot be broader than the main issue which Mr. Justice Andrew Baker was deciding. So you can say that it was a staging post on the way to his decision that any claim for the return of a refund fell foul of the rule. That would be necessary and essential insofar as it related to the claim pleaded against ED&F. But insofar as it was wider than that, it would be, as between SKAT and ED&F, a pure point of law. And not susceptible, and I'll come on to that, not susceptible, therefore, to issue estoppel.
Okay, can I know that we're taking up quite a lot of your time.
No,
I think this is the heart of the case.
It is the heart of the case, man.
Can I try a different analogy just to see if I've understood where you are? We know that Arnold and National Westminster Bank concerned the construction of a rent review clause in a lease. We know that once you've construed a lease, that construction can generate an issue estoppel. So all the subsequent rent reviews, you're stuck with the same construction unless you can prove special circumstances, which is what happened. Suppose the same landlord and the same tenant have 5 units on an estate which are let on identical terms on the same day, and they all have the same rent review clause, and one of them is litigated and the landlord wins and the tenant can't appeal, is the tenant stuck with that construction for the other 4 leases? Or does it depend? In other words, is the question all that the judge decided first time round was the construction of lease A, and leases B, C, D and E are not before him and nothing he decided can affect them? Or is the question, here's lease A, given his construction of lease A, which you're stuck with, and since there's no conceivable difference with B, C, D and E, you're stuck with them on B, C, D and E.
But if, for example, the leases B, C and D were made on different days...
Well, that's why I said made on the same day, same estate, same parties. The tenant might be stuck with those.
He might, but he would be entitled to point to something.
You say it would be up to him to say there's something different.
Well, I think it would be up to, in fact, the party relying on the estoppel to say
so you're stopped because there's no conceivable difference.
If you're the party claiming for an estoppel, you're the person who has to show there is no conceivable difference. So that, for example, you might say, in relation to a tax voucher, there's no conceivable difference of it being on blue paper rather than on pink. But if it turned out that the blue version of the tax of the tax voucher had some special significance within the Danish Tax Authority, I don't know, that it showed that it had gone and been approved by someone. You could see a world in which something that we've been banding around as obviously trivial might not be.
But how does that sit with your submission that the doctrine of issue estoppel is limited to issues which it was necessary to decide in the first set of proceedings? In my Lord's example, it wasn't necessary to decide anything about leases B, C, D and D. So why do you concede that the tenant would be bound, assuming no conceivable difference?
Well, it would depend, my Lord, I think, on the issues that were arising in that particular case. The trouble with these examples, I shouldn't be saying trouble. The trouble with the examples, of course, they're not causing trouble. But the point about them is that what we've seen from the cases is it depends so much on the particular situation that is arising. I think it's Lord Justice Wilmer talks about the importance of emphasising the particular circumstances of the individual case. And so one can respond to an example and take certain assumptions about that example on board and make a response. But that may, in fact, involve making assumptions that it would be beyond the party claiming an estoppel in those situations would not be able to establish. So I can see that if you've got lease A between the same parties and the other leases on the same day between the same parties are in identical terms, one can see that there may be no difference at all between them, and it may be possible to show that there is no conceivable difference because each of the properties to which they relate are absolutely identical. They're all flats in exactly the same building, exactly the same floor, and so on and so forth. But there may be things about them.
No, but assume there isn't any difference. I think the logic of your earlier submission is there still wouldn't be an issue estoppel because it's got to be necessary in the first set of proceedings to make the determination of the issue. And in the posited example, even if no conceivable difference between any of them, it wasn't necessary in the proceedings to say anything about leases B, C, D and D.
Well, my Lord, one needs to distinguish between the issue that's been decided and what is, as it were, also treated as being subject to an issue estoppel. So if you identify an issue that's been decided, and that is, shall we say for sake of argument, precisely the same, that may give rise to an issue estoppel. You may also get an issue estoppel by looking at those matters which are necessary, essential and fundamental to get to that point. But so far as the example of the leases is concerned, if the decision on lease A is precisely the same as the decision that arises on lease B, there's an issue estoppel because the issues are precisely the same. You don't get into the question of what is necessary essential or fundamental, because that is looking at what, as it were, the issue drags in its wake as other things which must be treated as between the parties and their privies as having been decided by the first issue. So I'm not saying, and I apologise if I've expressed myself clumsily, I'm not saying that in order for lease A to give rise to an issue estoppel, as with B, C and D, that it has to be a necessary, essential and fundamental decision of the party. That is, if you identify your issue, and you identify an issue which is precisely the same, then subject to the party claiming the estoppel proving there could be no conceivable difference, you've got the same issue, issue estoppel. You also have the potential for there to be further matters from which a party would be stopped in bringing, if those matters are something necessary, essential or fundamental to the issue you've identified. And what I'm doing, I hope, is saying the issue here is, were SKAT's claims as alleged against ED&F man inadmissible by the revenue rule? Now, there will be certain steps that will be involved in that decision, and those have to be necessary, essential or fundamental themselves to give ground to an issue estoppel. You can't go wider in our respectful submission than something that it is necessary, essential or fundamental to decide that issue. And that is why, if you're deciding that preliminary issue by reference to the claims pleaded against ED&F man, the fact that one of the staging posts in where you get to the decision may be an extremely wide proposition of law counts, we would say, for nothing. The only bit that counts is the application of that wide principle of law to the facts, because that is necessary in order to reach the decision that the particular set of claims against ED&F are inadmissible.
And just reverting to where I was, I think it would fit with your submissions that actually you say there was nothing necessary, essential or fundamental along the way which could create an issue estoppel. I mean, can you think of anything that you could have identified as a so to speak, an issue estoppel in relation to a sub-issue? I don't think it's compatible with your submissions.
No, well, I think looking at Mr. Justice Andrew Baker's judgment, the only thing one can say was that he looks as though he looked at the factual details of each particular case. And that I haven't taken you to that passage yet, but that is something obviously on which I would want to draw to your attention. He knew perfectly well that what he was doing was looking at the factual details of each particular case. He was then applying a very general approach, which is a slightly sort of one-size-fits-all approach to whether Dicey Rule 3 applied. My submission is that that is relevant only insofar as it relates to the case pleaded against ED&FM, because it was not necessary, essential or fundamental to that decision for Mr. Justice Andrew Baker to go any wider.
Even though we know that the reason why he reached that conclusion was because of a widely expressed general principle, that doesn't matter.
Doesn't matter at all. We're not seeking to apply Mr. Justice Andrew Baker's judgment as authority. We are seeking to see whether he has decided precisely the same issue, or whether anything he has decided is necessary, essential or fundamental to the issue which he did decide.
I mean, the issue that he had himself entrusted to himself included why.
Yes.
And he gave a reason why. So, in a sense, that is part of the answer to the preliminary issue he was deciding.
But his answer why is only relevant insofar as it relates to the claims pleaded against ED&F man. So the answer why is because these claims amount to claims for an attempt to recoup a refund, to get back a tax refund mistakenly paid out, and that, he says, falls foul of the revenue rule. But the why, it is no part of the why the claims against ED&F man should be inadmissible. That principle goes a good deal wider, as expressed by Mr. Justice Andrew Baker, because what that would be doing is seeking to infer or deduce from what Mr. Justice Andrew Baker said how he would have decided some other issue. And we are not, as I say, in the territory of seeking to apply that as an authority. We're looking to see whether we have a strict technical identity of issue and whether we can see whether there's anything else that is necessary, essential, or fundamental to that particular issue.
Do we have his order that he made after the revenue ruling?
No, we don't. I think the pruning that was done in order to try and get the bundle...
It presumably strikes out the claims.
It did strike out the claims.
Does it make any declarations as to why the claims were struck out?
No, we don't think it did. It just said the claims are struck out, I think.
Thank you.
So, my lords, I was saying just now.
Just for completeness, I think it would be helpful if we did have a copy of the order at some point.
Right. Yeah, okay. Can we get hold of that? So, my lord, I was just saying that the what one mustn't do, and with my it's my respectful submission that by seeking to apply the wide principles that Mr. Justice Andrew Baker thought were applicable, one runs the risk of going beyond what he needed to decide for the case as pleaded against ED&F Man, and to infer or deduce from that how he would effectively have decided this claim had it been before him, which it was not. The judge explains that it was a legal corollary of the principles set out in the cases he looked at in paragraph 37 of his judgment. In paragraph 38, he says, it's a logical corollary of that principle that a judgment does not create an issue of estoppel as to any matter that is inferred or deduced from the previous judgment. Issue of estoppel applies only as to the precise issue that was in fact decided by the previous judgment, and any other matter that it was necessary to decide and which was actually decided as part of the groundwork for the decision on that issue. So here, all the groundwork essential and fundamental to Mr. Justice Andrew Baker's decision that SKAT's claims against ED&F Man were inadmissible as a result of Dicey Rule 3 involved, we say, an assumption that the facts pleaded against ED&F Man by SKAT were true. And as far as concerns the point that an issue of estoppel cannot be enlarged by inference or deduction, there is a convenient summary of the relevant authorities in the judgment below. Can I ask, my lords, to pick up the judgment? That's in core bundle behind tab 6. Can we start on page 7? Can we look at page 77? So I'm looking at paragraph 35. Mr. Justice Bright has just set out the statement from Lord Justice Diplock in Todde and Todde, and then he says the judge then cites the decision in Arnold, which my learned friend took your lordships to yesterday, and the judge cited that for the proposition that in order for issue of estoppel to apply, a particular issue forming a necessary ingredient in a cause of action must have been litigated and decided. In paragraph 38, the judge referred to the statement in Spencer, Bower and Handley at paragraph 8.22 that issue of estoppel cannot be enlarged by inference, evidence or argument. We don't need to turn that up unless your lords would like me to, but it's in the Authorities Bundle, volume 3, tab 27 on page 957. And the judge then, within paragraph 38, referred to the Duchess of Kingston's case, which is authority for the proposition that issue of estoppel does not extend to any matter to be inferred by argument from the previous judgment. That case dates from 1766 and is in the Authorities Bundle at volume 1, tab 1, unsurprisingly, since they're in chronological order. And it's worth a read in any event. It's a case on the significance of a decision on the jactitation of marriage, which I think is a decision which is not binding as to whether a marriage exists or not.
What does jactitation mean?
I think one gets it from page 8 of the report. It's a special sort of claim that existed in those days in the ecclesiastical courts, where you could, if someone was saying that you either were married or weren't married, you could bring an action, and if you could establish enough, you could say that you were being the person who was saying you were either married or not married, as the case may be, was wrong, and they were then libeling you, and you had to stop. But it was not definitive. The point about it is not definitive as to whether there was a marriage or not. So there was a colourful lady who I think was married to one of someone called Harvey, who was a sea captain, and she then wanted to get married to the Duke of Kingston, and did. And the question was whether that marriage was bigamous. And she prayed in aid the fact that she had succeeded in a suit of jactitation of marriage some years earlier, but Sir William de Grey, I think it was, the Chief Justice, advised Parliament that that didn't give rise to an issue of estoppel, because it only showed it wasn't a conclusive determination that the marriage existed, or didn't exist. I think it wasn't a conclusive determination that the marriage didn't exist, and therefore the court's hands were not tied insofar as assessing whether her marriage to the Duke of Kingston was bigamous. But perhaps a more recent example of the application of the principle would be in order. And there the judge referred to the decision of Mr. Justice Hildyard in Re Lehman Brothers Holdings PLC, and that case is in the Authorities Bundle, Volume 3, Tab 25, at page 888. Given the time, I wonder, for present purposes, can I ask my lords to read to yourselves the judge's summary of Mr. Justice Hildyard's reasoning, which is set out in paragraphs 38 to 41 of the judgment. So you should have open page 77. If I could invite my lords to read 39, 40, and 41. That is where one's getting from a very recent case some of the principles which I've been seeking to put to your lordships. You can see the passage he quotes under 39. The fact that the approach of the court on an issue arising in one case may be determinative of a different issue in another case does not, without more, establish an issue of estoppel. The issue in the later case must be one which was expressly decided or a necessary and fundamental part of or step in the decision in the earlier case. Parity of reasoning or confluence in the reasoning of the two cases is not enough. Mr. Justice Hildyard based that in part on Blair and Curran, which I'll come on to in a moment, and what Lord Shaw said in Oisted and the Commissioner of Taxation. And then in his own judgment, Mr. Justice Hildyard added that a deduction from the earlier decision in circumstances where that earlier decision did not decide the issue was not sufficient for issue of estoppel. I agree. So again, he's looking at precisely, looking for precisely the same issue, and he's looking for seeing something which is necessary, essential, or fundamental to that, the decision on that issue. So what we say in relation to those cases is that in many cases it will be possible to infer or deduce from the earlier judgment how the reasoning in that judgment would apply to a new issue, or how that judge would have decided the new issue if that issue had arisen before that judge. But that does not give rise to an issue of estoppel. Rather, the party invoking issue of estoppel must establish that the issue that now arises for decision has in fact already been decided between the same parties on the previous occasion, either as an issue in precisely the same terms or as a matter necessary, essential, and fundamental to that decision or on some other issue between them. We say that ED&F man cannot satisfy this test, and that the judge was absolutely right to find that they could not do so.
It does depend how you characterise the issue. If the issue is, are the 420 tax voucher claims based on negligence within Dicey Rule 3, well, obviously, both the 5 new claims and the deceit claims on the same vouchers are not decided by that issue. But if you characterise the issue as, can SCAT sue in England for compensation for withholding tax refunds wrongly made, then that is decided, and it's decided against you. So how do you characterise the issue?
I characterise the issue in precisely the way that Mr. Justice Andrew Baker characterised it. He set out an issue for all the parties to the litigation, but obviously insofar as it relates to ED&F man, it relates to them. The wording of that appears at paragraph 13 of the judgment. We just pick it up
Yes, it's whether the claims as pleaded, but it does add the words "and why."
Yes.
So why is it not a necessary step in answering that issue for him to formulate, as he did, a proposition of law that SKAT's claims for compensation for withholding tax wrongly paid are within Dicey Rule 3? Why is that not a necessary step in answering the question?
Because it goes further than Mr. Justice Andrew Baker needed to go.
Yeah, okay.
You want. I think.
I think you've given that up. Yes,
Yeah.
I think I've asked you that before.
No,
but it's the same answer.
Yes. Yesterday, my lords, my learned friend took you to the decision in Blair and Curran. That is in the Authorities Bundle, Volume 1, Tab 4. And my learned friend took you to page A139. And my learned friend read the sideline passage, starting from "it is true that," right down at the bottom of the page, including the words at the end of that page, "but this difference appears to me to be one which could not affect the question of whether the interest of which the disposition had failed passed under the clause," going over the page, dealing with Tasmanian residue. So you may remember the reference to the Lucen Act and so on and so forth. Then my own friend stopped reading and he said, and this is quote from page 92 of the transcript yesterday, "So there were irrelevant factual distinctions between the two cases, did not undermine the operation of the issue of estoppel." But if we read on page A140, we can see that what Mr. Justice Dixon was there dealing with was whether the decision of Mr. Justice Street from 1907 should be followed as a matter of authority, not because of issue estoppel. That is clear when one looks from the beginning of page 140, where Mr. Justice Dixon said this: "For the court at this date to give the clause an interpretation contrary to that placed upon it by Mr. Justice Street in 1907 would, I think, be highly inconvenient. It would mean that the administration and winding up of the estate would in one case proceed according to one interpretation of the clause, and in another according to a contrary interpretation of the same clause. For if a case of lapse or failure could be brought within the direct operation of the decretal order, the interest, the disposition of which had lapsed or failed, would pass under the clause to the residuary legatees. But wherever a case of lapse or failure arose out of events or conditions which could be shown to fall outside the language of the decretal order, the interest would pass to the next of kin, notwithstanding that, so far as the interpretation of the will went, the cases were the same. Apart, therefore, from any question of issue estoppel," note that, "there is much to be said for our taking the course of following the decision of Mr. Justice Street as a matter of authority. It is a decision upon a question of interpretation which certainly cannot be said to be clearly wrong, and was given 32 years ago, and to depart from it would cause an incongruity." And the issue estoppel point
We need to read the next 4 lines.
Yes, yeah, but that's when he...
But in any case.
But in any case, absolutely.
There's an issue estoppel.
In any case, there's an issue estoppel. But the point is, the point that about not irrelevant factual differences not mattering was said in the context of applying Mr. Justice Street's decision as a matter of authority. When you look at what... when you look at the question of issue estoppel, which begins halfway down page 140, you end up with the material which I think my learned friend took you to yesterday, the second half of 140 and all of 141, where you end up with Mr. Justice Dixon quoting the phraseology of Mr. Justice Coleridge in the Crown against the Inhabitants of the Township of Hartington, Middle Quarter, where I think using Mr. Justice Coleridge's phraseology, Mr. Justice Dixon says, "The judicial determination concludes not merely as to the point decided, but as to a matter which it was necessary to decide, and which was actually decided as the groundwork of the decision itself, though not then directly the point at issue. matters cardinal to the latter claim or contention cannot be raised if to raise them is necessarily to assert that the former decision was erroneous. And so we say that's entirely in line, that passage, with the submissions I've been making to your lordships. Identity of issue, or something that is necessary, essential, or fundamental to the issue, giving rise to an issue of estoppel if it arises in precisely the same terms in a subsequent action.
Can I ask you about that? Are you not implicitly saying that the former decision was wrong? Since, I mean, if we pick up also 142, where Justice Dixon says there is no legal hypothesis which would account for the widow's life interest passing under it consistent with any narrow interpretation or effect. I mean, in circumstances where you're not suggesting that there is any narrower proposition that would sustain Mr. Justice Andrew Baker's decision, actually you're saying he was wrong. Now, we know he was wrong, but it is implicit in you running your case now that he was wrong. Because there is no narrower proposition that would sustain it.
My submission would be that the only matter that if there were to be an issue of estoppel, I would not be allowed to argue was that he was wrong insofar as it related to the case that he was then dealing with as between SKAT and ED&F man. That I would, if there were an issue of estoppel, I would not be able to say that he was wrong in what he decided as regards that pleaded case. It is quite open to me, in my respectful submission, to say he was wrong in relation to other cases that had not been dealt with as between SKAT and ED&F man by that stage. Yesterday, my Lord Justice Nugee asked my learned friend a question about pure points of law, and that set those more diligent than I behind me thinking overnight. We found an authority. I've given it to my learned friends this morning. I wonder if I might hand those up to your lordship.
Is this an Indian case?
It's the Senate.
Oh, the Senate, right. There is a reference. There is a reference. Spencer Bauer. Yeah,
there's a reference
to an Indian authority for that proposition.
Yes, there is, and that's also in there behind the tab. Right. So you should have the Senate behind the first tab, and then you should have Spencer Bauer. I think it's paragraph 8.04.
But not the Indian case.
Right. There's a reference to the Supreme Court of India having decided, and the editor saying this is correct. But I don't think we have the Indian case. The diligence did not. There was not enough time for the diligence to be exercised that far. So the question that my Lord Justice Nugee asked yesterday was this: does issue estoppel apply? This is from page 111, lines 4 to 14. Does issue estoppel apply to pure points of law like that, or does it apply to the application of points of law to the particular facts? Because if it's only the latter, the legal quality of the fact, then all it does is to stop SKAT from challenging the conclusion that the negligence claims are within Dicey Rule 3. Do you not have to establish that you can generate an estoppel from the pure point of law that underlies Mr. Justice Andrew Baker's decision, which is that claims for compensation to fill a hole in the tax take are within revenue claims? And in our respectful submission, the answer to the first of those questions posed by my Lord Justice Nugee is provided by the House of Lords in the Senate. And the main, that's 1985, One Weekly Law Reports, page 490. And then, as you can see, it was a decision of the House of Lords, Lord Brandon of Oakbrook, Lord Fraser, Lord Diplock, Lord Roskill, and Lord Bridge. And the only judgment, I think, was given by Lord Brandon. In that case, my lords, a Dutch court had held in a dispute between the same parties that an exclusive Sudanese jurisdiction clause applied. And one can pick that up from page 498 at G. You see against the letter G on page 498, issue 2 is whether whatever the answer to issue 1 may be, the appellants are stopped by the decision of the Dutch Court of Appeal from asserting that their claim does not fall within clause 27. Lord Brandon said this, going over the page at 499. He said, having regard to the decision of your Lordship's House in Carl Zeiss Stiftung against Rayner and Keeler, the Carl Zeiss case, 2 matters were not in dispute. The first is that, if an estoppel exists at all, it is that kind of estoppel which is known as issue estoppel per rem judicatam. The second matter is that in order to create an estoppel of that kind, 3 requirements have to be satisfied. The first requirement is that the judgment in the earlier action relied on as creating an estoppel must be A, of a court of competent jurisdiction, B, final and conclusive, and C, on the merits. The second requirement is that the parties or privies in the earlier action relied on as creating an estoppel, and those in the later action to which that estoppel is raised as a bar must be the same. The third requirement is that the issue in the later action in which the estoppel is raised as a bar must be the same issue as that decided by the judgment in the earlier action. And Lord Brandon went on to explain further down the page what on the merits means in the context of his first principle, sub C. He said this, the argument in relation to the first contention was that the judgment of the Dutch Court of Appeal was procedural in nature, in that it consisted only of a decision that a Dutch court had no jurisdiction to entertain and adjudicate upon the appellant's claim, and did not pronounce in any way on the question whether the claim itself, or any substantive issue in it, if it were to be entertained and adjudicated on, would succeed or fail. In my opinion, this argument is based on a misconception with regard to the meaning of the expression on the merits, as used in the context of the doctrine of issue estoppel. Looking at the matter negatively, a decision on procedure alone is not a decision on the merits. Looking at the matter positively, a decision on the merits is a decision which establishes certain facts as proved or not in dispute, states what are the relevant principles of law applicable to such facts, and expresses a conclusion with regard to the effect of applying those principles to the factual situation concerned. If the expression on the merits is interpreted in this way, as I am clearly of opinion that it should be, there can be no doubt whatsoever that the decision of the Dutch Court of Appeal in the present case was a decision on the merits for the purposes of the application of the doctrine of issue estoppel. In my view, therefore, the argument for the appellants on this point is misconceived and should be rejected. So what Lord Brandon is saying there, with the concurrence of all the other members of the House of Lords, is that for issue estoppel to apply, there has to be a decision on the merits, and that means a decision that has those features that I've just read out, Your Lordships, at 499 E2H. So it has to be a decision that involves applying any principle of law which is to be applied to the facts. And here, of course, we would say the facts are the facts which, because this was proceeding by way of the equivalent of a strikeout, are the facts pleaded in the statement of case. And so I cite that as further support for our submission that what is the only thing that can give rise to an issue estoppel is the decision, insofar as whatever Mr. Justice Andrew Baker decided was relevant to the case pleaded against, or the cases pleaded against ED&F man. The second
your answer to the question, can you have an issue estoppel in relation to a pure question of law,
is no.
Is that is no, because there's no such thing as a pure question of law.
Yes, you've got to have.
Well, because a decision on the merits can never just be a pure question of law.
Exactly.
If the decision is that there's no need to provide consideration in English law in order for a contract to be enforceable, that's not a pure question of law. It's still a decision that you apply that principle to the facts in the case, which is this is a contract that's being sued on.
So you would be the estoppel would give rise. The estoppel there would be the same parties could not argue in a subsequent action that there was no consideration on the facts of that particular case. So here, we cannot argue, if there is an issue estoppel created, it's not a relevant one, because all it would prevent us from doing would be to say an argument, a case that we are no longer running, falls foul of the revenue rule. What you can't do, in our respectful submission, is go beyond what was necessary, essential and fundamental to Mr. Justice Andrew Baker's decision as to how the Dicey Rule 3 applied to the case pleaded against ED&F, and to say because he expressed himself more widely, that gives rise to a wider issue estoppel. It doesn't. It doesn't, because the only decision on the merits is the decision that on the facts pleaded against ED&F, there was this inadmissibility under Dicey Rule 3. And it just doesn't matter that Mr. Justice Andrew Baker expressed himself in terms so widely. You can see what he would have decided if a range of other claims had been brought before him and it had been suggested that they might fall foul of Dicey Rule 3. It doesn't matter, because that is not what has been decided as between SCAT and ED&F.
And this probably doesn't matter either, but for completeness, I see that Lords Fraser, Roskill and Bridge agreed with Lord Brandon, but also with Lord Diplock. And if you go to 494, you get just below A, Lord Diplock dealing with what on the merits means. He says what it means in the context of judgments delivered by courts of justice is that the court has held that it has jurisdiction to adjudicate upon an issue raised in the cause of action to which the particular set of facts gives rise, and that its judgment on that cause of action is one that cannot be varied, reopened or set aside, and so on. And then at G, he says that the hearing of the appeal from that state was repeatedly urged upon your lordships that all that the judgment of the Dutch court had done was no more than to hold that it had no jurisdiction over the dealer's claims against the ship owners, and so did not fall into the category of a judgment on the merits, but this is to confuse issue estoppel with cause of action estoppel. And then he says at the bottom, in my view, what that constitutes a final judgment on the merits upon two issues. The first is that the dealers have no claim against the ship owners for their wrongful act. And the second is that the effect of the jurisdiction clause is to make any remedy enforceable only in a Sudanese court. I don't know if that takes things any further, but at any rate, that was what Lord Diplock was saying.
Yes, in relation to that, my lords, I would pay particular attention, invite your lordships to look particularly closely at 494B, where he's asking, Lord Diplock is saying what the phrase "on the merits" means in the context of judgments delivered by courts of justice is that the court has held it has jurisdiction to adjudicate upon an issue raised in the cause of action to which the particular set of facts give rise. And so the same
presumably has no jurisdiction or can't.
Or exactly.
Yes.
The point is that for a decision on the merits, you need that melding, that combination of a decision on the facts. And if you're looking at what the facts are on this case, the facts were the facts pleaded against ED&F, and it doesn't matter that any expressions of legal principle of which delivered by Mr. Justice Andrew Baker went wider than that, because the only issue as between SCAT and ED&F in the preliminary issue trial was whether those claims pleaded were fell foul of the rule or not.
Well, most cases are going to involve either questions solely of fact or mixed facts law applying. But if what we're concerned with is issue estoppel, then one can formulate some issues that are pure questions of law, divorced from the facts. Of course, they then have to be applied to the facts, but that doesn't tell you whether issue estoppel can apply to an issue, which is a pure question of law. So it may not be a very good example, but the example I posited was, does English law require consideration in order for a contract to be enforceable? That's might be thought to be a pure question of law, which, as an issue, Which, of course, you then have to apply to the particular
Yes.
facts of the case to say, can this claim succeed or not?
Absolutely.
So there can be a pure question of law,
there can be a pure question of law, but I don't
which
think...
can engage issue estoppel.
No,
Because?
because it's not a decision on the merits.
I'm not sure I quite understand.
So if in litigation between A and B, the judge enunciates a general proposition that consideration is no longer required in English law, and therefore on this contract, where it's said that there's no consideration, the contract is valid, we know, I think you would accept, that would have stopped the parties from subsequently disputing that contract was invalid.
Exactly right, my lord.
But you say it wouldn't have stopped the parties from disputing that another contract between them was invalid for lack of consideration.
Correct, my lord.
Even though the enunciation of the principle that consideration was no longer required is a necessary step in the reasoning which led the judge to decide the case in the way he did.
Well, it wasn't, with the greatest respect, my lord, it was that on the facts of that case,
Yes, I see.
there was, it didn't matter that there was no consideration.
I suppose that was the only issue in that case, and suppose that the only issue in the subsequent case on the new contract is, does English law require consideration? Why, as a matter of policy, should that fall outside the scope of issue estoppel, when the policy is essentially to prevent the same parties on an identical issue being put to the trouble of relitigating, the winning party being put to the trouble of relitigating the identical issue? Why, as a matter of principle, should there be any difference?
Because I think, my lord, it would create an issue estoppel that was much too wide. It would be, in any action brought between A and B subsequently, it would no longer be open to A to say this contract is bad for consideration, even if it was 20 years later.
But I mean, subject to special circumstances, obviously.
Leave special circumstances.
Some subsequent authority that said that's not the law might well give rise to Arnold and Westminster considerations. But leave aside that. Why should that be a problem? Let's say that this was argued out at huge expense over many days, and that they got their decision from the court on the issue. Why shouldn't they be bound by that in relation to the identical issue in subsequent cases?
Well, firstly, my lord, because in our respectful submission, the case law on issue estoppel establishes that if it was sought to say that there should be further protection for party A, it may be that an abuse of process argument would be available, but it would not be issue estoppel. Because issue estoppel, in our respectful submission, does require there to have been a decision on the merits, and that does mean that the decision has to be applied to a factual situation. So there is a difference, we say, between the question, does there have to be consideration for an enforceable contract? That's an issue of pure point of law. But for an issue estoppel to arise, it would have to be, is this contract enforceable despite there being no consideration, for example? And that then you've got your tethering to the facts that mean you don't then have an issue estoppel of potentially wide ambit, depending on obviously the number of actions that A might bring against B over the succeeding years. But it seems instinctively wrong, in my respectful submission, that you could just say a party is not allowed to make a submission on a point of law as against another party, because that's been decided against him on one particular set of facts, and he now can't raise it in relation to another set of facts. And that would seem to me to be quite a surprising proposition.
Even if the facts are immaterial to the issue of law?
That's...
that's inherent in the example we're talking about.
Yes, I think
you are saying that.
I think even so. Yeah. Even so.
It might not seem so absurd if you had a whole series of contracts, each of which lasted a year, which were in materially identical terms, and you litigated the first one and A lost, could you relitigate the second one? Or I suppose you would say that...
I'd say that's New Brunswick sort of territory.
Yeah.
I mean, you might be able, as the party wanting to bring the case, you might be able to discharge the burden of saying there is no conceivable, no possible,
difference.
you could maybe discharge that. But absent that, then no, the position is that issue of estoppel is very strictly confined, it's very technical, and one needs to tread very...
Can I just understand where you stand on one very particular thing? I think I know where you stand, but just to be clear. So suppose you have a contract with an exclusive jurisdiction clause in it, and one party brings a claim alleging a breach of that contract, and it is determined that the jurisdiction clause applies. Now that same party wants to bring a claim for a completely different breach of the contract. Is there an issue of estoppel? I mean, the facts alleged are different, but they're relying on the same contract.
Well, I think my answer is going to be you don't know until you know enough about the facts of the second case and the extent to which they might differ. If one just says it like that, then unless it is established beyond all possible doubt that there could be no relevant difference between the two, then there wouldn't be an issue of estoppel. But if there were, if you could establish that identity of issue, then you could have an issue of estoppel. But it would require the party seeking to rely on the estoppel to establish that absolute identity, that precise identity.
So let me take a slight variation. An arbitration clause. The contract contains an arbitration clause. Claim is brought for a breach of contract. Answer from the court: can't do that because there's an arbitration clause. Now you want to allege a different breach of contract. Can you fight that out again?
That would seem more difficult.
So what's the distinction?
The distinction is that it looks as though the facts that you're suggesting are exactly the same in the second action. That you're bringing a claim for breach of a contract where it has already been decided as a necessary part or as a previous decision between the parties that this particular contract is subject to that particular bar.
Not this particular claim.
Sorry, my lord, I'm being
Sorry, not this particular claim. So you make that concession if they're both claims in contract, but you wouldn't. Would you make that concession if in the first set of proceedings the claim was for breach of contract and the court said all claims, whether brought in tort or contract, are governed by the arbitration clause, and the second claim was brought in tort?
Exactly. Yeah, I wouldn't accept it then. You're right.
Because you would say that
Because
the
I would
determination in the first proceedings
Was-
about the nature of claims that are caught by the arbitration clause was wider than was necessary
Exactly.
to decide
decide.
whether the contract claim was caught in those proceedings.
Yeah.
Have I understood how
You have.
how
You have.
how you would answer?
That is right. That is how we put it.
Yep.
My lords, behind the tab in your little bespoke bundles, there is the quote from Spencer Bauer, which I think my lords were already ahead of me on. There it was. I'm glad it was behind the tab. But you see down at the bottom of the page, determinations may be of fact or law. The determinations which will find an issue of estoppel may be of law, fact, or mixed facts and law. Examples of the first include issues of construction. In Hoisted, a case I think my own friend took you to, it was the application of a revenue statute to a will, and in Blair and Curran and Re-Waring, the construction of wills. In road traffic cases, the issues have generally been questions of fact or mixed factor law, the Supreme Court of India has held that there can be no issue of estoppel as to a pure question of law. And there's a reference made to Johnson and Sousa, but I'm afraid we haven't got that for you. But the editors of Spencer Bauer say this must be correct.
Yes.
And
I wonder whether when Mr. Krishna Prasad has got more leisure, he might be able to find that for us.
yes,
and
as far as I'm
provide it.
aware, my lord, he has no leisure at all. I will ask him to find some.
Thank you.
So what both of those new authorities show that, we say, if any issue of estoppel arises from Mr. Justice Andrew Baker's decision, it is because he took certain facts as true for the purposes of the Revenue Rule trial, applied Dicey Rule 3 to those facts, and stated his conclusion on the application of the principles to those facts. There is no issue of estoppel in our respectful submission as to pure statements of law that he made in the Revenue Rule judgment outside of the facts alleged against ED&F man.
When you say both of those new authorities, you mean Senna and the statement, the four-word statement, this must be correct.
Sorry, my lord.
It's just, I wouldn't normally refer to a textbook as
No,
an
I'm sorry,
authority,
no,
but that's what you meant.
That's what I meant. Forgive me, it was rather, I spoke casually.
I was being slightly facetious.
Thank you. So, my lords, in applying those principles taken from the cases to the facts, the first question in our submission that arises is what is the precise issue that Mr. Justice Andrew Baker decided? And we say the issue that Mr. Justice Andrew Baker decided was the preliminary issue as between SCAT and ED&F. May I now show your lordships how the judge below identified the issue that Mr. Justice Andrew Baker decided. And for that we need tab 6 of the core bundle at page 78. And as the judge said at paragraph 45, the terms of the preliminary issue are reproduced at paragraph 13 of the judgment. We've already looked at that. It's on page 74. But again, it's worth looking at it one more time. The wording of the issue is, are any of SCAT's claims as alleged inadmissible in this court under the rule of law stated, e.g. as Dicey Rule 3? If so, which claims are inadmissible and why? Now, I know my lords will have read this before, but can I ask you, please, to go back now to page 78, and can I remind you of what the judge said at paragraphs 45 and 46 of the judgment? He said, the reality is that the issue considered and decided by Mr. Justice Andrew Baker at the Revenue Rule trial was the issue that he had defined at the CMC in a formulation that he repeated in his judgment. The formulation was set out at paragraph 13 above, and then there's a reference to the precise formulation. Mr. Justice Andrew Baker used the same formulation again in his order on the judgment, also of 27th April 2021. It's another reason why it would make sense to get hold of a copy of that order. The limiting words, as alleged, meant as pleaded, or on the facts pleaded. I note that this was acknowledged by SCAT when it sought permission to appeal on ground 1. The wording of that ground was that the judge had erred in his determination of the applicability of the Revenue Rule to SCAT's claims as alleged. SCAT explained the meaning of this in paragraph 5 of its skeleton argument, i.e. The skeleton argument for the application to the Court of Appeal. I have, my lords, as if by magic, been handed a bunch of copies of the order made by Mr. Justice Andrew Baker on the 27th. So the point I was just making, my lords, was about the wording of the issue That appears halfway down page 2, which I have on the bottom right-hand corner, C/126/2. So Mr. Justice Andrew Baker, his order recorded that he was deciding that preliminary issue, and then you can see the terms of his order.
It looks as though the answer is what we see in the judgment, does it?
Well, the formal order is that the claims are dismissed.
Yes.
Yeah.
But he recites the judgment as well as the issue.
Yes.
Put it this way, there's no other answers to the question. No.
I think you accept we have to look at his judgment to identify what issue he decided. Oh, sorry, how he decided. How he decided.
How he decided. I think it's our
issue.
respectful submission that it's pretty clear what the issue is he decided. That, in our respectful submission, is not, say he decided a range of things, but I think the decision he thought he was deciding was the one he had ordered to be the subject of the trial. It'd be quite odd if he ended up deciding something else. The question is, what is necessary, essential and fundamental to his decision on that issue, we say. And we say what is necessary, essential and fundamental for that is limited, so far as ED&F man are concerned, as between SKAT and ED&F man, to the case pleaded against them. At the time the revenue rule took place, SKAT had brought claims against a large number of defendants. My note says there were 114 at the time. I think my friend told you there were 106. There were a lot of defendants. The second part of the preliminary issue makes clear that in the revenue rule trial, Mr. Justice Andrew Baker was considering whether Dicey Rule 3 did or did not apply to each of SKAT's claims against each of those defendants. And I will explain, as I will explain a little later, that is relevant to issue estoppel, because in order to decide whether SKAT is stopped from bringing the current claim against ED&F man, it is necessary to focus on the precise issue that Mr. Justice Baker decided as between SKAT and ED&F man. The judge rightly focused on that issue, and I will show you, Lordship's, passages from the judgment that make that clear a little later. But spoiler alert, they're going to be paragraphs 47 and 49. The essential point there, my lords, is this. Assume a world in which the preliminary issue was tried only as between SKAT and ED&F man in isolation. If in a judgment on that preliminary trial, Mr. Justice Andrew Baker had expressed his views on whether a fraud claim would or would not have been inadmissible under Dicey Rule 3, any such observations would plainly have been unnecessary for Mr. Justice Andrew Baker to decide the pleaded issues as between SKAT and ED&F man. And I can illustrate that by looking at a sentence from the judgment of Mr. Justice Dixon, again in Blair and Curran, which your lordships were taken to yesterday. It is the statement on, it's volume 1, tab 4, page 141. And I think you were taken to this yesterday at around about 8 minutes past 2. And the sentence is this: nothing but what is legally indispensable to the conclusion is thus finally closed or precluded. And we say, as you see, that's the first sentence of the middle paragraph, the only things legally indispensable to the conclusion on a preliminary issue as between SKAT and ED&F man related exclusively to the claims pleaded by SKAT against ED&F man. What my learned friends are seeking to do in our respectful submission is to untether the issue that was decided at the revenue rule trial from SKAT's pleaded case in the earlier proceedings. And they seek to do that in two ways. First, they say the judge was wrong to focus on the words "as alleged." They say those words do not limit the effect of Mr. Justice Andrew Baker's decision to the allegations that SKAT had made in the pleadings, by reference to which the revenue rule trial was conducted. That is their ground 1.3 of their grounds of appeal. That's in C tab 1, page 15. Worth just briefly looking at that. see at the bottom of the page, the learned judge erred in law by concluding that the reference to the claimant's claim as alleged in the definition of the preliminary issue heard at the Revenue Rule trial limited the effect of Mr. Justice Andrew Baker's judgment to the specific factual or legal allegations relied on by the claimant in the original proceedings. And they make the same point in their skeleton, paragraphs 51 and 52, that's C, bundle C, /3/30. Unless you'd like me to, I'm not going to go to that given the hour. And second, they say the detailed underlying facts of a case are irrelevant to Dicey Rule 3. They say that it is only the central interest pursued by SKAT or the substance of SKAT's claim that matters. And that point is repeated a number of times in their skeleton. For example, paragraphs 12, 45.1, 47.1, sub 1, 47.3, sub 2, and paragraph 49. But both those contentions are wrong for the same reason. A Revenue Rule trial was concerned with the application of Dicey Rule 3 to the facts pleaded by SKAT in the earlier proceedings against ED&F Man. And it is by reference to those pleaded facts at all three levels that the courts determined the nature of the right asserted by SKAT or the substance of the claim brought by SKAT for the purpose of Dicey Rule 3. Now, in order to make good that submission, I should now show you, my lords, a couple of passages from Mr. Justice Andrew Baker's ruling, under which he ordered the Revenue Rule trial. That ruling is in the judgments bundle, so that's bundle J, behind tab 1. And I wonder if I might invite my lords to read to yourselves paragraph 7 on page 6, so J/1/6, paragraph 7.
Yeah, I'll do that.
And your lordships will have picked up the terms of the case management issue, case management issue 65, which are reproduced in that paragraph, are missing the words as alleged, which we saw in the preliminary issue that was tried at the Revenue Rule trial. The reason that Mr. Justice Andrew Baker added those words is apparent from the next two paragraphs. In paragraph 8, Mr. Justice Andrew Baker said this: having reflected carefully on all of the submissions in relation to that issue, it is my view that it is by nature and suitable for determination as essentially a strikeout issue. It could have been raised, as it seems to me, by an application to strike out some or all of the causes of action as pleaded on the basis that they infringe what we may find ourselves calling, for shorthand, Dicey Rule 3. And then in the first sentence of the next paragraph, paragraph 9, he says this: as it seems to me, it is a significant and it may be an important point concerning the nature and the scope of that rule of law and how it applies to the causes of action alleged by SKAT. But that is the nature of the issue, that is to say, an argument of law. So the task, we would say, that Mr. Justice Andrew Baker set for himself was, just as he would have done on a strikeout application, to apply Dicey Rule 3 to the causes of action pleaded by SKAT on the assumption that SKAT's pleaded case against each of the defendants was correct on the facts. The nature of that exercise is also reflected in Mr. Justice Andrew Baker's Revenue Rule judgment, and that is at bundle 2 of the same bundle we've got open. My learned friend took you to this yesterday, but can I start with Mr. Justice Andrew Baker's summary of the applicable principles, which you'll see under paragraph 75 on page 42. And might I invite my lords to reread to themselves subparagraphs little Roman 1, little Roman 4, and little Roman 5.
I'm so sorry, which paragraph?
Sorry, it's 75 on page 42, behind tab 2, and it's under the heading Applicable Principles.
Thank you.
Yeah.
And so Mr. Justice Andrew Baker considered that in order to determine the admissibility of a claim under Dicey Rule 3, first, it was necessary to look at the substance of the claim. Second, the substance of the claim was to be decided by reference to the central interest which was being pursued in bringing the claim. And three, in determining the central interest, the mechanism by which harm was said to have been caused to the defendant was relevant. Well, how does a court decide what the central interest is in relation to a given pleaded claim and what the relevant mechanism of harm might be? Well, Mr. Justice Andrew Baker explained how he approached that question a little earlier in paragraph 67 of his judgment, and that is on page 39 of the bundle. And he says there, I therefore accept a submission by Mr. MacDonald QC that in considering the question of characterization raised by Dicey Rule 3, the mechanism of harm is important. How it is said that the allegedly wrongful conduct caused the harm in respect of which the claimant pursues a claim, including the nature, quotes, open brackets, character, close brackets, of any actions, including decisions, those words in brackets, of the sovereign that were involved. It may indeed be central to the analysis in a claim brought by a sovereign entity against private parties alleging tortious conduct, brackets, e.g. deceit, conspiracy, negligence, close brackets, as it was in Mabasogo. How the claim is put against the defendants is treated by Dicey Rule 3 as a matter of form rather than substance. The whole point of the rule, exemplified by Buchanan against McVeigh or Mbasogo, is to look past the fact that the claim has been framed in a way that a claim might be framed between private parties, treating that as a matter of form, to examine and identify the central interest served by the pursuit of the claim. Considering the mechanism of harm as alleged, note the words as alleged, including the sovereign function, if any, involved therein, at the level of the factual detail of the particular case, not in the abstract, as for example, additional personnel costs or payments induced by fraud, is both appropriate and likely to be unavoidable in that exercise. And so, my lords, we say that makes it very clear that in the last sentence of that paragraph, Mr. Justice Andrew Baker said that his approach was, in order to identify the central interest that SCAT was pursuing, for example, in its claim against ED&F, and the mechanism of the harm it suffered, it was both appropriate and likely to be unavoidable to look at the factual detail of the particular case. May I ask, my lords, to look next at paragraph 108 of the judgment. I think my learned friend read you paragraphs 107 and 109. 108 is also worth a peek. Looking at the bottom of page 50, Mr. Justice Andrew Baker said in that paragraph, as I said in paragraph 35 above, that is not to say that SCAT could never pursue here a claim for damages for a tort committed against it because it is a sovereign tax authority. And if then we jump down to the last two words on the page, SCAT may, and then going over the page, be the victim of a tort that is not a tort against the Danish fisc. On one view, that is what the argument on the scope of Dicey Rule 3 comes down to. Considering the nature of SCAT's pleaded claim, in substance, so again we would stress those words, considering the nature of SCAT's pleaded claims, in substance, SCAT is alleging torts against the Danish fisc, with the collection and management of which SCAT is charged, rather than torts against SCAT as a legal person conducting business or personal affairs akin to those that might be conducted by a private party. And my lords, our submission is that it is clear from those two passages that I've just showed you, the distinction that my learned friends seek to draw between the substance of, or the central issue behind a claim on the one hand, and the factual detail of that particular claim on the other, is a false distinction. And that is because the court decides the central interest behind, or the substance of a claim being pursued by a claimant by looking at the underlying facts, or where the matter is being treated as a strikeout, the pleaded facts. This is also the basis upon which both the Court of Appeal and the Supreme Court approached the Dicey Rule 3 issue on appeal from Mr. Justice Andrew Baker's decision. Now, in the interest of time, I'm not going to take my Lords through the Court of Appeal's judgment in any detail, but for my Lord's notes, the judgment is behind tab 4 of Bundle J, and the relevant passages for this point are those at paragraphs 127 and 137. The relevant pages of the bundle are 134 and 136.
But why are we concerned at all with what the Court of Appeal or the Supreme Court said?
Only
If the issue estoppel, which is relied upon, is solely by reference to Mr. Justice Andrew Baker's judgment.
what I'm relying on them for, my Lord, is to show that the correct approach as a matter of law is that you look at the issue that's been decided by reference to the pleaded facts. So not only was Mr. Justice Andrew Baker right in paragraph 67 and 108 of his judgment to say that, but his view is that you've got to start with the pleaded facts is supported both by the Court of Appeal and by the Supreme Court.
I follow.
There are a couple of passages I wish to show your Lordships from the Supreme Court's judgment. That's behind tab 6 of Bundle J, which we're currently in. And as my Lords will know, the unanimous judgment of the Supreme Court in this case was given by Lord Lloyd Jones, and Lord Lloyd Jones addressed the manner in which Dicey Rule 3, which by then had become Dicey Rule 20 sub 1, was to be applied he addressed the manner in which it was to be applied to the facts of paragraphs 37 and 38 of his judgment. And those passages start at page 234 of the bundle. And in paragraph 37, at the very bottom of that page, Lord Lloyd Jones said this: "Turning to the application of these principles to the facts of this case, the essential question is whether the substance of the respondent's claim as pleaded is a claim for the direct or indirect enforcement of foreign tax laws. For this purpose, it must be assumed that the respondent will be able to prove at trial the facts alleged in its pleadings. In my view, it is clearly not a claim for the direct or indirect enforcement of foreign tax laws." And then in paragraph 38, Lord Lloyd Jones said this: "An examination of the substance of the respondent's pleaded claim shows that it is not a claim for sums due as tax in Danish law, nor is it a claim that the appellants are liable to the respondent because they've cheated the respondents out of tax which was due to it. It is not alleged by the respondent that any sums are due from the appellants as tax, nor is it alleged that any of the appellants were at any time under a liability to pay tax. Indeed, on the pleaded case, there has never been any unpaid tax in this case. The respondent has been paid all the tax to which it was entitled by the genuine shareholders in the Danish companies. The substance of the claim is not to recover tax, but to recover payments made by the respondents which were induced by fraud and to which the recipients were not entitled on any basis. It is a claim by a victim of fraud for reimbursement of the sums of which it's been defrauded." And so the only point for citing those passages to my Lords is this: the Supreme Court also proceeded on the basis that the preliminary issue which Mr. Justice Andrew Baker had required to be tried required the court to apply Dicey's Rule 3 to SKAT's pleaded cases to the facts. Although obviously by the time we were in the Supreme Court, the pleaded cases against different people. But the point is, the principle is that the substance of the claim for these purposes is to be determined by reference to the fact that SKAT had pleaded.
Yes, but there's repeated reference to the substance of the claim.
Yes.
Not to all the facts.
No.
And the substance of the claim must presumably mean that those aspects of it which are of importance in determining whether Dicey Rule 20 applies or not.
No, my Lord, I don't think that is.
Why doesn't it just say the terms of the claim in every? Why is Lord Lloyd Jones looking at the substance of the claim?
Because he wants to see what, if one goes with what the way Mr. Justice Andrew Baker put it, you're looking at that to see what the central interest in bringing the claim is. So what is the central interest in bringing a claim for negligent misrepresentation? Well, you need to look at the substance of that case. It's a case that says you represented this. When you represented that, you owed me a duty. That duty you breached because those representations were false and you were careless about making them. That's the substance that Lord Lloyd Jones is saying. If he was dealing with, obviously he's not dealing with negligent misrep, he's dealing with fraud, because he's dealing with the parties who were party to the Supreme Court appeal. But that's what he's looking at. He's not looking at what was the substance of Mr. Justice Andrew Baker's decision. You look at the substance of the claim by reference to the facts pleaded, and that enables you to make an evaluation as to whether it engages the rule or not. And so here we say it's absolutely essential to Mr. Justice Andrew Baker's decision that he grounded himself in relation to all claims, first and foremost, on the factual details of each particular case. Last sentence, paragraph 67. Absolutely critical in our respectful submission. This is not, I don't need to look at the facts. I'm telling you what the relevant principles of law is, regardless of the facts. He's saying, I've looked at all the facts that have been pleaded, and in each case, I'm saying, I'm looking at what the mechanism of harm by which SKAT claimed to have been injured was, and I'm then looking at what the central interest was of SKAT in bringing the claim. But that is rooted in, unavoidably, he says, it's appropriate and very likely unavoidable to ground yourself in the factual details of the particular case.
Yes, I don't have any difficulty with that submission. I think where the fault lines are is whether that means all the facts or only those facts which are material to the resolution of the issue as resolved. And all I was putting to you is that what the language of Lord Lloyd Jones, talking about looking at the substance of the claim, seems to be one in which he's seeking to identify not every single fact which is alleged, but those that matter.
I would agree with that. But the only point at which I cavilled was that I think he's looking at characterising the claims that have been made, and that does not, as it were, just mean looking at only those points which are ex hypothesi relevant to the decision. You've got to look first at what the claim in substance is, and off the back of that, you then decide whether Dicey Rule 3 applies. I think there's a risk of getting things the wrong way round if you say the only thing I need to look at is the facts that I already know are going to end up being relevant to Dicey Rule 3. You've got to look at what the substance of the case is in our respectful submission, and then decide whether Dicey Rule 3 applies. It's not good reasoning in our respectful submission to say all that Mr. Justice Andrew Baker was ever going to be interested in was his principle that any attempt to get compensation for mistakenly paid refunds must fall foul of the rule. No, that's not the way in our respectful submission it should be looked at. The way it should be looked at is what was pleaded, what's the substance of that claim. Now, looking at the substance of that claim, is it inadmissible by Dicey Rule 3? And I think there's a risk if you do it the other way round and you say what's important for Dicey Rule 3, brackets, knowing the answer that Mr. Justice Andrew Baker gives, that's the wrong way of looking at it in our submission.
Thank you.
So, my Lord, the difference in SKAT's pleaded case are, we say, start. In order to decide whether issue estoppel applies, we say it's necessary to look at SKAT's pleaded case in the earlier claim and the pleaded case based upon which SKAT brings the present claim. The judge conducted this exercise in paragraphs 47 and 69 of his judgment. And can I ask you, please, to look at those. Core bundle, we need to put the judgment bundle away. And look at, behind tab 6, Mr. Justice Bright's judgment at paragraph 47, where he says this. This is on page 78. In the original proceedings, what was alleged in respect of the claim against ED&F Man, in the sense of the facts that have been pleaded, was negligent misrepresentation. The facts pleaded did not amount to fraud. The cause of action pleaded was not deceit. Just pausing there, my lords, there are 2 points worth noting about that analysis. The first is the judge's focus on what was alleged in respect of SKAT's claims against ED&F Man, and that is also reflected in the first sentence of paragraph 48, where the judge referred to the issue as between SKAT and ED&F Man in the revenue rule trial. And again, as my lords now well know, this is a point we lay some stress on. In deciding whether there was an issue of estoppel between SKAT and the ED&F Man, the judge was entirely right to focus on the issue that had been decided as between SKAT and ED&F Man, rather than as between SKAT and any other defendant. The second aspect of that paragraph that I wish to emphasise is the judge's analysis that what was alleged in terms of the fact that had been pleaded was a case in negligent misrepresentation, and that the facts pleaded did not amount to a case in fraud. It was the factual details of the case in negligent misrep, as pleaded, that underpinned Mr. Justice Andrew Baker's determination of the central interest that SKAT had in bringing that claim, and thus his decision on the preliminary issue as regards SKAT's claim against ED&F Man. Again, paragraph 67 of his judgment final sentence, J/2/39. The factual details of the case in fraud that SKAT now brings against ED&F Man are significantly different from the factual details of its earlier case in negligent misrepresentation. The judge explained as much at the second of the 2 paragraphs that I said I would take you to just now. That is paragraph 69, which is at page 84 of the bundle. And can I ask my lords please to look at that paragraph. In the first sentence, the judge says, identifying the differences between SKAT's pleaded case against the ED&F Man in the original proceedings and its pleaded case in the 2022 proceedings is not straightforward. And then he said this, however, the significant elements of the new case which were not present in the original proceedings and which together have enabled SKAT to put its case in terms of fraud are the following. And may I then ask your lordships please to read to yourselves the 4 significant elements that the judge identified.
We'll do that.
Thank you.
Yes.
Thank you. So, in our submission, my lords, when one reads paragraphs 47 and 69 of the judge's judgment together, it is clear that the judge was not saying that the only difference between the earlier claim and the current claim is the fraud allegation. He was saying that there are important factual allegations that SKAT makes in the current claim which were not pleaded as part of the earlier claim and which have cumulatively enabled SKAT to put its case in terms of fraud. And it is clear from paragraphs 47 and 69 taken together that the judge was certainly not saying that the only difference between the earlier claim and the current claim was a mere matter of form, with the same pleaded facts relied on in support of the earlier claim in negligent misrep, now being used to support the new cause of action alleged in deceit. It is clear from both paragraphs, 47 and 69, that the judge was not focusing merely on the differences in the causes of action alleged, but on the differences in the essential factual allegations based on which SKAT had pleaded those 2 causes of action. And in order to demonstrate that the judge was right in his analysis I just showed you, I was next going to propose to show your lordship some of the key allegations that SKAT had pleaded in the earlier claim and compare them to the facts pleaded in the current claim.
I'm conscious we've slayed you up a lot this morning.
I am going much less well through my notes than I had hoped.
Yes. I wonder, that being so, whether we ought to do this exercise now if it's not going to take too long.
Then fine. So may I start by taking your lordships to SKAT's re-amended particulars of claim in the original proceedings. That's Bundle S, Volume 1, Tab 10. And that was the main body of SKAT's particulars of claim at the time when ED&F man was a party to the earlier proceedings. Might I invite my lords first to look at subparagraph 3K, which appears at the bottom of page 149 of the same tab and goes over to page 150. 3K, SKAT's claim against ED&F Man Capital Markets Limited, the 69 defendant in the first claim, ED&F Man, is set out at Schedule 5T. For the avoidance of doubt, SKAT does not allege fraud or dishonesty against ED&F Man, or that the ED&F Man applications were made as part of a fraudulent scheme. Re-amended Schedule 5T begins at paragraph page 164 of the same bundle, and I think you were taken to this by my learned friend yesterday. You can see from the opening page the causes of action that SKAT relied on were unjust enrichment, dealt with very briefly, and negligent misrepresentation, dealt with in rather more detail. The representations alleged to be made by ED&F Man to SKAT were set out at section B3, which is at page 166. And paragraph 9 reproduced the relevant text from the tax vouchers issued by ED&F Man. Do you see at the bottom of the page the words, paragraph 10, each tax voucher contained the following express representations by ED&F Man to SKAT. And then there are 4 of them listed on the next page, page 167. Can I invite my lords to read those very quickly to yourselves?
Yes.
And then you'll have seen in paragraph 11 the allegation that the tax vouchers contain the following implied representations. Those implied representations are in subparagraphs A and C. Might I invite you quickly to read those to yourselves as well?
Yes.
And you will have seen that the representations pleaded in paragraph 10D and 11A were concerned with beneficial ownership. That is a concept of international tax law, and I'll show you in a moment SKAT's pleading as to the meaning of that concept. And when I come to the allegations of falsity, I will also show you, my lords, the concept of beneficial ownership was a key aspect of SKAT's pleaded case in the original claim, whereas it forms no part of SKAT's current claim. But before I do that, may I make this point? My lords will have seen an annex to my learned friend's skeleton, which compares the representations pleaded in the earlier claim with the alleged representations in the current claim. That's at C, tab 3, page 44. And my learned friends say that based on that annex, the pleaded representations are very similar. They say that in paragraphs 29.1 and 47.2 of their skeleton, those being at pages C/325 and C/329. But I think since we're looking at the pleaded representations, it is worth taking a quick glance at the annex. Behind tab 3, it's the last page before you get to tab 4. And you see the annex is headed Comparison between the alleged representations in the original claim and the current claim. And on the left-hand side of the table, my learned friend set out the representations pleaded in the original claim. But my lords will note, if they look carefully, that they only refer to the 4 representations pleaded at paragraphs 10A, 10B, 10C, and 11C. The representations pleaded at paragraph 10D and 11A are conspicuously missing. And as my lords have just seen, both those representations were concerned with SKAT's case as to beneficial ownership. It is only by omitting those representations that my learned friends are able to make the point that the representations pleaded in the earlier claim and the current claim are very similar. And that reflects, my lords, a broader point. A very large part of SKAT's pleaded case in the earlier claim was based on the allegation that even if ED&F man's pension plan clients own shares and receive dividends, as to which SCAT did not plead a positive case, the beneficial owner of those shares and dividends was ED&F man itself, not the pension plan clients. By contrast, the basis of the current claim is that no shares were owned by the pension plan clients at any material time, no dividends were received by them, and no tax was paid by them. On that basis of putting the case, the question of beneficial ownership of shares simply does not arise. Turning back, if I may, to Schedule 5T, the allegations of falsity of the pleaded representations are set out in paragraph 18 at page 170. And do my lord see there, the ED&F man representations were false in the following respects. And then paragraph 18A is the allegation of falsity in respect of the applications identified in Annex E to ED&F man's amended defence. And you'll remember, my lords, that Annex E were those applications in respect of which ED&F man admitted that they hadn't received dividends and I think and that they hadn't suffered a withholding of tax, but it did not go any further than that. Your lordships will see from the opening words of subparagraph B that the tax vouchers produced in support of the Annex E applications comprised 80 out of 420 vouchers that SCAT relied on in its claim against ED&F man. Now, can I invite my lords to read subparagraph A to yourselves?
Just, I'm wondering whether
Yeah.
I might be taking this too far.
Yes.
How much longer do you think the pleading exercise will take?
On the pleading exercise,
It's got a little way to go.
it's a little way to go.
Yes. In that case, I think we might break.
Yeah.
We'll start again at 2. How badly off course do you think you are?
I've got a little way to go on issue of estoppel, and then it really, I don't know whether I might take abuse of process a little more quickly.
Yes.
I want obviously to leave Mr. Krishna Prasad his moment to deal with the Aldi guidelines, but I think he can be as brief, not as my lords want.
Well, I know you've had an awful lot of questions to deal with, but can you, over lunch, take stock between you so that we do finish on time, allowing Malik some time to reply?
Yes, of course, my lord.